Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Fulani versus Hogsett, 917 F2D 1028, Court of Appeal, 7th Circuit, 1990. Friends, today we're going to talk about ballot access and ballot restriction. Yes, a third party in this case sued for ballot restriction. So what's that all about? Let's find out. This case involved the New Alliance Party. Have you ever heard of them? It sounds like they're an older party. I don't hear about them these days. So they don't sound to be prominent anymore. I've never seen them on a ballot as far as I can remember. But from what I read in this trial, they once had a good backing. So let's read from the record. It says, quote, in the 1988 presidential election, plaintiffs Lenora Fulani and Mamie Moore were the respective candidates for president and vice president of the United States on behalf of the New Alliance Party. They appeared on the presidential ballot in Indiana and 49 other states, along with the Democratic and Republican candidates. The other plaintiffs in this case include Fulani's election committee, the New Alliance Party, a campaign worker, and an Indiana voter who supported the New Alliance Party, collectively New Alliance. New Alliance claims that Indiana electoral officials denied equal protection of the laws and violated 42 U.S.C. 1983 when state officials allowed both the Democratic and Republican candidates on the ballot after the Indiana Secretary of State failed to certify their electoral candidates by August 1st, 1988. The district court granted the defendant's motion to dismiss the case prior to the election, and New Alliance appealed. End quote. The New Alliance Party is not to be confused with the Alliance Party. The Alliance Party is much newer. Did you hear that? They got on 49 states. That's a good job for ballot access. So good job, Fulani. In every other case I've seen, the third parties are suing to get on the ballot. In this case, they're on the ballot, but they want to strike the Democratic and Republican candidates off the ballot because they didn't get the deadline in time. That's a very bold and gutsy move. Wouldn't that be something else if they did get the Republican and Democratic Party off the ballot, or even just one of them? That would be something. I'm not sure how I feel about the tactics of that. Like the podcast American Resolution by the Sam Party puts it, there is a place for the two parties. They just can't dominate everything. So I believe that's similar in my heart. I don't want to abolish the Democratic and Republican parties. I certainly don't want to use the law to make them illegal. So they have a place, indeed. The New Alliance Party sees it as they did their job. The two parties didn't do their job, so they shouldn't be on the ballot. All these other cases I read, they want to make the third parties stick to every regulation possible. But here, the two parties didn't meet the regulations, but they still get on the ballot. I like to see what this New Alliance Party is doing here. I like to see this. I applaud this. Good job, friends. Good job. This case hinges on what they call the theory of latches, which means, according to the judges here, if you have an injury, you got to fight with urgency. You got to take action right away, because they argue if you don't take action right away, it's not that bad for you. They do concede a point by our friends here of the importance of needing to restrict the ballot access of the Republicans and Democrats. It says, quote, without the Republicans and Democrats on the ballot, New Alliance would have gained additional press exposure and could have conceivably won the Indiana election. No small boon for a relatively obscure party that hoped to establish a national presence. End quote. What happened to the New Alliance party? What happened? They were so big, yet these days they're not here anymore. This podcast focuses on cases 1990 and above, and this case was in 1990. It dealt with the election in 88 because it was 1990. I decided it qualified for the criteria of this podcast. So wouldn't that be awesome if that situation happened where the Republicans and Democrats didn't get on the ballot, so then the New Alliance Party would have won? That would be something else. Unfortunately, the judges decided that because of that latches stuff, our friends here wouldn't get any justice. They say the following, quote, because of the disposition of the case on latches, we do not need to reach other issues involving equal protection, section 1983, or pendant jurisdiction. The judgment of the district court is affirmed. End quote. I admire what the New Alliance Party did. From what I understand, they're a socialistic type party. I don't know if I would vote for them. I haven't had the option, so it's not something I've had to consider. But I am willing to vote for socialist parties, as I have in one election at least before. I voted for the Socialist Workers' Party in the 2008 election for president. So the New Alliance Party, I imagine, has some great ideas, so they're worthy of consideration. Shall they rise again? Good job, New Alliance Party. Good job at your boldness. Good job. Long live third parties. Goodbye.